Welcome to Underworld UK, where Britain's darkest stories are brought to light. From the gritty streets of gangland London, Liverpool, Manchester and Birmingham, from Curtis Warren to the Cray twins to county lines and modern-day true crime, we cover everything. Bringing you new videos every week. Subscribe so that you'll be notified when the next video is put out.
Ashley Warren is sentenced to 10 years in prison for owning one of two XL bully dogs that mauled his mother-in-law to death. The dog, named Bear, killed Esther Martin while she was at Warren's home in Essex in February 2024, 2 days after the breed was banned. The judge describes the incident as a sustained and repeated attack that lasted at least 12 minutes and bans Warren from owning a dog for life. Martin's daughter tells the court her mother was the centre of the family and a death has left a void which cannot be filled. Ashley became the first person to be charged with XL bully-related offences that came into force in February 2024. These are the rules. Esther's mother Sonia says her mother had a great laugh and a wicked sense of humour. She'll be remembered for being a great friend to many, a sister, an aunt, a grandmother and a great-grandmother. But to us, she always was and always will be our mum. Esther's daughters became very emotional as they spoke. At one point, they were holding each other's hands as they said, "This sentence is more than just a number of years. It is a validation of the pain we have endured and a step towards protecting other families from the same nightmare." Esther Martin's daughters have told the press they are pleased with the sentence. Together they read a joint statement in front of Essex police station, watched by other members of the family and Esther's friends. "We are grateful the court had recognised the gravity of this tragedy. It sends a clear message that the lives of our loved ones are precious and that those responsible for such preventable heartbreaks will be held to the highest standards." Ashley Warren previously told the court how Bear was dopey and a bit like a teddy bear. He described Beauty, below, as gentle and loving. But the two dogs were responsible for mauling Esther Martin to death in Jaywick in Essex in February 2024. Warren was found guilty of being the owner of Bear, but the jury cleared him of being in charge of Beauty, which the court heard belonged to his girlfriend. Ashley Warren was away in London filming a music video at the time Esther Martin was attacked in his home. The court heard he got the train back to Clacton railway station as soon as he heard about what had happened. Essex police officers were there waiting. There was disruption at Court 1 earlier when Sonia Martin Cuppen read a victim impact statement following her mother's death. One male stood up in the public gallery, about 5 metres, 16 feet, from the dock. He waved his arms and pointed at Warren, swearing and telling him, "I'll sort you out." A crowd stood to prevent the man walking towards the dock. He continued shouting, describing the defendant as a mug. Another man joined in. Warren also waved his arms and looked visibly angry, but his words were drowned out. The first man was led out of court, while the second continued the verbal attack. Judge Jeremy Johnson KC warned that anyone causing further disruption would be asked to leave. The moment Ashley Warren was sentenced to 10 years and 3 months in prison was broadcast live on the BBC. Mr. Justice Jeremy Johnson KC described Esther Martin's death as a foreseeable incident. "We have now heard from the police following this afternoon's sentencing. DCFI Louise Metcalf, who led the investigation, says, 'Our thoughts today are with Esther's family, as they have been throughout our investigation. No sentence can ever bring Esther back, but I hope this result will help them to move forward.' She describes the investigation as a challenging and complex, noting that it was the first of its kind in the country following the change in legislation. 'I want to thank my team for their diligence, professionalism and dedication,' she adds. Their hard work has ensured Ashley Warren has been held accountable for Esther's death. 2 adult XL bully dogs, Beauty and Dare, and 8 of their puppies were at the house in Jaywick in February 2024 when police arrived. The trial heard how each puppy weighed about 10 to 12 kilograms each, with all the dogs weighing 180 to 190 kilograms in total. All of them were destroyed following the attack on Esther Martin. We are now going to listen to the actual judge verdict and sentencing.
Ashley Warren, you were convicted by a jury of being the owner of a dog which, while dangerously out of control, caused injury, resulting in the death of Esther Martin. The jury also convicted you of an offence of having an article with a blade or point. Today, you've pleaded guilty to 2 additional offences of possession of a prohibited dog. Esther Martin was 68. She was a much-loved mother and grandmother. She has been described as kind, fun-loving, funny, unique, and one in a million. The court has heard deeply moving statements from her daughters Sonia Martin and Kelly Fretwell and her son Paul Martin. Those statements vividly explain the impact your offending and her death and the manner of her death have had on her children and on all who loved her. No sentence can reduce their loss or take away their pain or reflect the infinite value of her life. You are 41. You've been convicted of 15 previous offences. Those include offences of robbery and assault and breaching a non-molestation order. The most recent convictions before the matters that are now before the court were in 2015 for 2 counts of assault occasioning actual bodily harm and affray, putting you in breach of a conditional discharge. On that occasion, you were sentenced to a total of 56 weeks imprisonment. In February 2025, you were the owner of an adult male XL Bully dog. You also possessed an adult female XL Bully dog. They were each large and powerful dogs, even by the standards of XL Bully dogs, weighing 47 and 39 kilograms. They had a litter of puppies. You kept 8 of the puppies with the adult dogs in your house. You were aware that a law was coming in to ban XL Bully dogs. That law came into force on the 1st of February 2024. You knew that the breed was banned from that date, but you did not take any steps to comply with the law and the requirements imposed on those who had XL Bully dogs. None of the dogs were neutered. None were muzzled. You did not have any certificates of exemption. More than that, you did not properly look after the dogs. They were confined in too small a space, and you had not walked them in the 4 weeks prior to Esther Martin's death. That greatly increased the risk of aggressive behaviour from them. When you were challenged about the dogs, as you were, you said you did not care what anyone said. Esther Martin was so concerned about the dogs that she was thinking of secretly reporting them. You knew how even the puppies were capable of causing injury. You'd referred to injuries that you had sustained from them. And you certainly knew how strong and potentially dangerous the adult dogs were. You knew that Esther Martin could not hope to control them. She was just 5'3", with a history of medical complaints, including a hip replacement, osteoarthritis, and diabetes. She was not stable on her feet. On the 3rd of February 2024, you arranged for Esther Martin to look after a pre-teenage child at your home while you went to London to record a music video and to meet a person who you described as your lady friend. Whilst you were away, it appears that the puppies may have started fighting. It's possible that an attempt was made to separate them, and whether in the course of that or otherwise, Esther Martin fell to the ground. The two adult dogs responded by attacking her. She was mauled to death. She sustained dozens of dog bites to her back, her chest, her abdomen, her head, and all 4 limbs. She suffered a catastrophic bleed, which resulted in her death. The dogs were so aggressive that police officers were initially unable to enter the property. The adult dogs had to be destroyed because they posed a continuing further risk to life. Esther Martin was the first person to be killed by an XL bully dog after the new law came into force. It was just 2 days after that law came into force, but it had been widely foreshadowed and advertised for many months before that. When you were on your way back home, you were arrested by police at a railway station and found to be in possession of a knife. You have a high degree of culpability for the Dangerous Dogs Act offence. That is because you knew that the dog was prohibited and because there are no lower culpability factors. Your counsel made a submission that you could not reasonably have foreseen the incident. I acknowledge the care and responsibility with which that submission was advanced, but I do not agree with it. I am sure that you could and should have reasonably foreseen the risk. As well as knowing that the dog was prohibited, you knew that it had been pent up in the house for weeks. You knew that it was of a type that was capable of being aggressive, and you knew that Esther Martin could not control it. The incident was foreseeable, and indeed had been foreseen by those who had sought to warn you about the dogs. That is so, even though there had not been a previous similar incident with these dogs, and even though on other occasions the dogs had been well behaved, and even if the precise mechanism by which Esther Martin was attacked could not have been predicted. I accept that the dog was not trained to be aggressive, and so you do not have a high degree of culpability for that additional reason. I apply the Sentencing Council guideline for this offence, adopting the high culpability bracket. The starting point for sentence is 8 years custody, and the range is 6 to 14 years. Your previous convictions are a statutory aggravating feature, but I take into account that you have not previously been convicted of an offence relating to animals, and that your last convictions before February of 2024 were for offences committed in 2013. The fact that Esther Martin was not capable of controlling the dogs is not in itself an aggravating factor, because it is inherent in the offence. But her physical immobility, her age, and her health meant not just that she could not hope to control the dogs, but also that she was unable to defend herself from them, and she was particularly vulnerable to injury. This was a sustained and repeated attack lasting at least 12 minutes and resulting in multiple injuries. You also put a child's life at risk, and you also potentially put at risk the lives of members of the public and emergency responders. That is because on at least one occasion, one of the adult dogs had escaped from your home, and also because anyone who attempted to break into the house to rescue Esther Martin would have been put at lethal risk. In addition, you had failed to respond to warnings and concerns about the dogs, expressed by others, and you kept them in conditions which increased the risk that they would become aggressive. A number of these factors arise from your same general attitude and course of conduct. I've been careful not to double count them, but in aggregate they demonstrate a sustained pattern of disregard for the law and for the lives and safety of others. I treat them collectively as a substantial aggravating feature. As to mitigation, I have taken account of everything that has been put before me on your behalf in your counsel's careful mitigation. Once you were informed of what was happening, you did take some steps to try and arrange for a friend to intervene. You are the sole carer of a child in their early teens. Their mother very sadly died, and that child now faces the additional trauma of the incarceration of their father for a substantial period of time, and you face the enforced separation from your child. The principal reason why I asked for a pre-sentence report was to assess the impact on them of your incarceration. That report shows that adequate arrangements have been made for their care, but I do take into account as mitigation the impact that the separation will have on you and on them, and also the serious medical condition that afflicts the person who will have parental responsibility for them. I've had close regard to a letter written by the child to me. To the extent that you may have undiagnosed attention deficit hyperactivity disorder, as set out in the pre-sentence report, there is no evidence that has any impact on your culpability. I do not accept that you have shown any genuine remorse. You maintained not guilty pleas, thereby putting Esther Martin's family through the trauma of a contested trial, and you continue to maintain that you are not responsible for Esther Martin's death, claiming it was an unavoidable accident. That is not in law an aggravating feature, but you are not entitled to any reduction in sentence on account of remorse. The aggravating factors that I have outlined substantially outweigh the mitigation and require a substantial uplift from the category starting point. I will not impose separate penalties in respect of the offences of possession of a prohibited dog, because that is a feature that is relevant to you having a high culpability for this offence. I have therefore already taken it into account. In respect of the bladed article offence, the starting point is 6 months custody, and the range is 3 months to 1 year. The knife was carried on public transport for a considerable period of time, but it was kept in a bag and it was not brandished. Your previous convictions are an aggravating feature. The same mitigation applies, but in this case it outweighs that aggravating feature. I am sentencing you for 2 different offences of a different character and which are completely unrelated. It's appropriate to pass consecutive sentences. I make a reduction to the sentence I impose for the bladed article offence to ensure that the overall sentence passed is just and proportionate, and that it reflects your overall offending behaviour. Given the completely separate nature of the offending, only a modest reduction is appropriate. I make a disqualification order for life under Section 4 of the Dangerous Dogs Act 1991. That means you may not in the future have custody of a dog unless or until a court terminates this order. I impose a lifetime disqualification because your conduct demonstrates a sustained and deliberate disregard of the law, the exposure of others to serious and foreseeable risks, a failure properly to care for the dogs, and an absence, even now, of any real insight on your part as to your offending. That, together with the catastrophic consequences of your actions, shows a continuing and significant risk to the public if you ever again own or keep a dog. A lifetime disqualification is therefore necessary and proportionate for the protection of the public. I make a deprivation order in respect of the knife, and I impose the statutory surcharge in the sum of £228 or such other sum as is required by statute. In the light of such evidence as I have as to your means and the lengthy custodial sentence that I will impose, I do not make an order that you make any contribution towards the prosecution costs. Only a custodial sentence can be justified for these offences. As required by law, I will impose the shortest sentence that is commensurate with the seriousness of the offences. You will serve 40% of the sentence I impose in custody. After that, you will be released on licence. You must comply with the terms of the licence and commit no further offence, or else you will be liable to serve a further period in custody. Ashley Warren, please stand up. For the offence under the Dangerous Dogs Act, I sentence you to 10 years imprisonment. For the offence of being in possession of a bladed article, I impose a consecutive sentence of 3 months imprisonment. The overall sentence is therefore 10 years and 3 months imprisonment.